This is a New Year's edition of the WCAG Wire for Friday, January 2nd, 2026. Current legal standards: ADA Title II, ADA Title III, and Section 508. Information verified as of 2100 UTC. Bottom line up front. Fifth Circuit issues major rulings on sovereign immunity and election law in consolidated Texas voting rights cases, narrowing circumstances under which state officials can be sued under Ex parte Young. Separate Fifth Circuit panel affirms vacatur of $116,359.69 attorney fee award in Houston petition circulator case following prior appellate determination that no Article III case or controversy existed from the outset. Beginning with the Fifth Circuit issuing a comprehensive decision on December 31st, addressing sovereign immunity defenses raised by Texas Secretary of State Jane Nelson and Attorney General Ken Paxton in consolidated challenges to Texas Senate Bill 1, the Election Protection and Integrity Act of 2021. The lead case, La Unión del Pueblo Entero versus Abbott, consolidated multiple lawsuits filed by voting rights organizations challenging 38 provisions of SB 1 under the U.S. Constitution, the Americans with Disabilities Act, and the Voting Rights Act. Case numbers 22-50775, 22-50777, and 22-50778. Writing for the majority, Circuit Judge Priscilla Richmond held that the Fifth Circuit has appellate jurisdiction over denials of sovereign immunity even when proper application of immunity does not lead to dismissal of all remaining claims. The panel explicitly followed its recent precedent in Mi Familia Vota versus Ogg, rejecting plaintiffs' argument that jurisdiction required complete immunity from all claims. On the merits, the panel conducted provision by provision, ex parte Young analysis, applying the three-part test requiring 1. Particular duty to enforce the statute, 2. Demonstrated willingness to exercise that duty, and 3. Acts that compel or constrain persons to obey the challenged law. The court held that Secretary Nelson lacks sovereign immunity for 14 provisions of SB 1. The court's reasoning distinguished between regulatory authority and enforcement authority. For Sections 2.05, 2.06, and 2.07, provisions operationalizing the Secretary's duty to sanction voter registrars who fail to comply with voter registration list requirements, the panel found direct enforcement authority. Section 2.05 requires the Secretary to establish a monthly comparison system between the statewide voter registration list and Department of Public Safety databases to verify citizenship status. Section 2.07 mandates quarterly comparisons to identify voters no longer residing in their registered counties with mandatory notification to registrars. Section 2.06 imposes escalating sanctions on non-compliant registrars, including mandatory training, audits, and referral to the Attorney General for civil penalties. Judge Richmond emphasized that the Secretary's role is central to the voter registration maintenance process. The court rejected the Secretary's argument that only county registrars enforce these provisions, reasoning that the Secretary's notification and sanctioning powers give her direct authority to compel registrar compliance. The panel found the Secretary demonstrated willingness to enforce based on her predecessor's announcement of a full forensic audit of the 2020 election and directives to registrars to verify voter eligibility. For provisions governing early voting and mail-in ballot forms, Sections 5.01, 5.02, 5.03, 5.08, 5.10, and 5.13, the court applied its 2020 precedent in Texas Democratic Party versus Abbott, which held that the Secretary's duty to design official ballot application forms constitutes enforcement of substantive voting requirements. The panel reasoned that because local authorities must use Secretary-prescribed forms except in emergencies, quote, the Secretary has the authority to compel or constrain local officials based on action she takes as to the application form, end quote. The court found this logic equally applicable to new identification requirements imposed by SB 1, including wet signature mandates and government ID documentation requirements. The panel extended similar reasoning to voter assistance and ballot delivery form provisions. Sections 4.12, 6.01, 6.03, 6.05, and 6.07. Section 4.12 requires election officials receiving in-person ballot deliveries to document voter information on Secretary-prescribed rosters. Section 6.01, 6.03, 6.05, and 6.07 impose documentation requirements on individuals transporting 7 or more voters or assisting voters in casting ballots. The court held that the Secretary's authority to prescribe these mandatory forms constitutes sufficient enforcement connection under Ex parte Young. The panel distinguished its 2022 decision in Lewis v. Scott, where it held the Secretary did not enforce signature verification procedures. Judge Richmond explained that Lewis involved provisions regulating the ballot verification process itself, not form design. The court further reasoned that referral to prosecutors who themselves lack enforcement authority cannot constitute enforcement by the Secretary. Citing its 2023 decision in Ostrowich v. Tatum, the panel noted that under the Texas Constitution, the Attorney General has no independent authority to prosecute election-related criminal offenses. Therefore, quote, it would be illogical to conclude that the Secretary enforces either Section 2.08 or the substantive provisions by referring criminal conduct to an official who cannot independently enforce these provisions. The panel held that receiving information about potential violations, standing alone, does not constitute enforcement. For ballot verification and signature verification provisions, the court applied its 2022 decision in Richardson v. Flores, which distinguished form design authority from verification process authority. These provisions assign verification responsibilities to early voting clerks, signature verification committees, and early voting ballot boards, not the Secretary. Section 5.07 requires clerks to reject deficient applications and provide notice to applicants. Sections 5.11, 5.12, and 5.14 specify procedures for constituting signature verification committees and correcting ballot defects. The panel held these provisions, quote, deal with the ballot verification process, specify which officials are tasked with enforcing them, and require those officials to exercise discretion. For early voting location provisions, Sections 3.04, 3.09, 3.10, 3.12, 3.13, and 3.15, the court cited its precedents in Me Familia Vota v. Abbott and Texas Democratic Party v. Hughes, holding that local election officials, not the Secretary, administer early voting sites and determine polling place locations. Section 3.04 prohibits curbside voting except for voters unable to enter polling places. Sections 3.09 and 3.10 establish mandatory early voting hours. Sections 3.12 and 3.13 require polling places to be in physical buildings, not movable structures. Section 3.15 eliminates straight ticket voting. The panel held that the Secretary's authority to adopt rules and establish procedures does not constitute enforcement authority, distinguishing regulatory power from enforcement power. Regarding Attorney General Paxton, the majority held he is a proper ex parte young defendant only for Section 2.06. That provision authorizes the Attorney General to bring civil actions to recover penalties against counties whose registrars fail to substantially comply with voter registration requirements. The court found this express statutory authorization for civil enforcement distinguishes Section 2.06 from provisions the Attorney General can only enforce through criminal prosecution, where he lacks independent authority under Texas constitutional law. The panel rejected the Attorney General's argument that plaintiffs failed to demonstrate his willingness to enforce Section 2.06. Citing the Attorney General's October 2021 press release announcing formation of an election integrity unit and his office's representation of having brought 510 election offenses against 43 defendants with 386 active election fraud investigations, the court found sufficient evidence of enforcement intent. The panel distinguished this from its 2020 decision in Texas Democratic Party v. Abbott, where it held that a letter to election officials warning of potential criminal liability did not establish enforcement authority because the letter made no specific threats and was not directed at plaintiffs. However, the court held sovereign immunity bars all other challenges to the Attorney General. The panel applied its 2023 decision in Ostrowich v. Tatum, which held that Texas Election Code Section 273.021a, providing that the Attorney General may prosecute a criminal offense prescribed by the election laws, does not overcome sovereign immunity because the Texas Court of Criminal Appeals ruled in State v. Stevens that this statute violates the Texas Constitution. The Fifth Circuit explained that, quote, the Attorney General has no independent authority to prosecute election-related criminal offenses and therefore does not have the ability to compel or constrain local officials to enforce the electioneering laws. The majority further held that SB 1 Section 8.01, which establishes civil liability for election officials who violate the election code, does not provide clear statutory authorization for Attorney General enforcement. The court noted that the Attorney General himself argued before the Texas Supreme Court in Paxton v. Longoria that he lacks authority to enforce Section 8.01. Because the Attorney General has not demonstrated willingness to enforce Section 8.01 given his representations in Longoria, the panel found no basis for applying the ex parte Young exception. On standing, the panel exercised pendent appellate jurisdiction to address whether plaintiffs satisfied the traceability element for provisions not barred by sovereign immunity. Citing Texas Democratic Party, Ver Abbott, and OCA Greater Houston v. Texas, the court held that plaintiffs alleged sufficient connection between defendants' enforcement authority and plaintiffs' alleged injuries. Plaintiffs asserted that challenge provisions expose their members to investigation and prosecution, force organizational resource diversion, and burden voter registration and get-out-the-vote activities. The panel found these allegations sufficient to establish traceability where the Secretary's sanctioning authority over registrars and form design authority directly implement challenged requirements, and where the Attorney General's civil enforcement authority under Section 2.06 compels registrar compliance. Circuit Judge Andrew Oldham issued a 45-page partial concurrence and partial dissent. Judge Oldham agreed the Fifth Circuit has collateral order jurisdiction over sovereign immunity appeals, but dissented from all holdings, allowing suits to proceed. Judge Oldham's dissent criticized what he termed the circuit's no-nexus rule, the practice of requiring connection between state officials and challenged laws without requiring connection between state officials and specific plaintiffs. Judge Oldham argued that Ex parte Young requires state officials to have enforcement connection, quote, against the plaintiff, not merely general enforcement authority. He traced Ex parte Young's historical foundation to the principle that when a state officer threatens to enforce state law in a manner violating a plaintiff's federal constitutional rights, the officer acts ultra vires and loses state sovereign immunity protection. Judge Oldham contended that the majority's analysis focuses on whether defendants enforce provisions against anyone, rather than whether defendants enforce provisions against these plaintiffs specifically. Applying this framework to the voter registration provisions, Judge Oldham noted that plaintiffs purport to represent voters, but the Secretary's sanctioning authority operates against county registrars, not voters. He reasoned that, quote, only the registrars can inflict constitutional injuries on the plaintiffs by forcing them to either provide costly proof of citizenship or cancel their voter registrations. Judge Oldham argued that the Secretary's notification and sanctioning powers are, quote, attenuated at best, because the Secretary cannot force registrars to remove any particular voter from registration lists and can only sanction registrars for substantial non-compliance with overall duties. For form design provisions, Judge Oldham argued that the Secretary's regulatory role, quote, has absolutely nothing to do with the plaintiff's constitutional arguments. He noted that plaintiffs complain about the burden of presenting identification information to local voting officials, not about form design itself. Judge Oldham emphasized that local clerks, signature verification committees, and ballot boards, not the Secretary, are statutorily required to subject plaintiffs to the new ballot and application requirements. He argued that enjoining the Secretary, quote, would not afford the plaintiffs the relief that they seek, because it would not relieve local officials of their obligation to reject applications that do not comply with the new requirements. Judge Oldham similarly criticized the majority's holding regarding the Attorney General and Section 2.06. While acknowledging the Attorney General has civil enforcement authority against counties, Judge Oldham argued this authority has, quote, zero connection to the plaintiffs, because the Attorney General has zero ability to remove voters from the registration lists and has zero authority to throw out applications or ballots. Judge Oldham contended that even enjoining Attorney General civil prosecutions against counties, quote, doesn't remove the obligation of voter registrars to reject non-compliant applications, require voters to sign prescribed forms, and provide identifying information, end quote. Judge Oldham's dissent articulated broader concerns about circuit precedent, creating what he characterized as an illegitimate writ of erasure, allowing federal courts to strike down state laws without proper Article III nexus between defendants and plaintiffs. He argued that current Fifth Circuit doctrine permits any plaintiff to sue whenever any defendant has enforcement authority, regardless of whether that defendant can enforce the law against the specific plaintiff. Judge Oldham warned this approach, quote, arrogates to federal courts an illegitimate erasure power, end quote, inconsistent with Ex parte Young's foundational principles and Article III's case or controversy requirement. In other news, on January 2nd, a different Fifth Circuit panel affirmed vacatur of a $116,359.69 attorney fee award in Poole v. City of Houston, a case involving constitutional challenges to Houston charter provisions requiring petition circulators to be city residents and registered voters. Writing for the panel, Circuit Judge Dana Douglas upheld the District Court's grant of the city's Federal Rule of Civil Procedure 60B5 motion for relief from the fee judgment. Case number 24-20138. The decision represents the Third Fifth Circuit appeal in protracted litigation spanning 6 years. Plaintiffs: Joe Richard Poole III, Trenton Don Poole, Accelerate 2020 LLC, Liberty Initiative Fund, and Paul Jacobs sought to circulate a petition for a ballot initiative limiting campaign contributions from city contractors, but were ineligible under charter provisions requiring circulators to be Houston residents and registered voters. Before filing suit, plaintiffs contacted the city, which initially expressed uncertainty about its position on the qualified voter requirement, but approximately 1 week later indicated it would not enforce the provision. Plaintiffs nonetheless filed suit in federal court seeking injunctive and declaratory relief. The district court granted a temporary restraining order in July 2019 enjoining enforcement of the charter's residency and voter registration requirements. After the circulation period ended, the parties agreed to dismiss claims as moot. Plaintiffs appealed, arguing the case was not moot regarding future petitions. During the first appeal, the city inserted an editor's note in the charter indicating it would accept petitions from non-residents who were not registered voters, with a hyperlink to a non-resident petition form. In Pool 1, decided in 2020, the Fifth Circuit reversed and remanded. Holding that one, plaintiffs had standing to seek declaratory and injunctive relief for future petitions because plaintiffs, quote, had reason to believe the city would be seriously intent on continuing to enforce the qualified voter requirement, and 2, the city's post-suit disavowal did not moot the case because it was unclear whether the city had made any formal policy change. On remand in February 2022, the district court granted the city's motion to dismiss claims for permanent injunctive relief while simultaneously granting plaintiffs' summary judgment motion for declaratory judgment that the challenged charter provisions were unconstitutional. Only after entry of that order did the city notify the court it had passed Ordinance Number 2022-455, which eliminated the charter's qualified voter requirement and allowed non-residents and non-registered voters to circulate petitions. The district court entered final judgment in July 2022, dismissing all claims with prejudice. While the second appeal was pending, plaintiffs filed an amended motion for attorney's fees under 42 U.S.C. Section 1988B, arguing they were prevailing parties under Buchanan Board and Care Home v. West Virginia Department of Health and Human Resources, 532 U.S., 598 and 604. The district court granted the motion, reasoning that plaintiffs satisfied the three-factor test for prevailing party status: 1. Achieving judicially sanctioned relief through both a TRO and declaratory judgment. 2. Materially altering the legal relationship because the city adopted Ordinance Number 2022-455, quote, in direct response to the declaratory judgment. And 3. Modifying the city's behavior in a manner directly benefiting plaintiffs. The court calculated fees and expenses at $116,359.69, which the city paid. In Pool 2, decided in 2023, a different Fifth Circuit panel issued a 4-paragraph unpublished opinion concluding the case presented a, quote, faux dispute because, quote, all parties have agreed from the beginning of this case that the charter provisions were unconstitutional. Making no reference to the previously published Pool 1 decision, the panel held that, quote, where the parties agree on a constitutional question, there is no adversity and hence no Article 3 case or controversy. The panel cited only the city's brief for the proposition that all parties consistently agreed the provisions were unconstitutional. The panel vacated the final judgment and remanded with instructions to dismiss plaintiffs' claims without prejudice. On remand following Pool 2, the district court granted the city's Rule 60B5 motion seeking dismissal without prejudice, vacatur of the attorney fee award, and reimbursement of the $116,359.69 paid to plaintiffs. The court reasoned that it could properly relieve the city from the fee award because the order upon which the award stood was, quote, based on an earlier judgment that had been reversed, when Pool 2 held no case or controversy existed. On appeal, plaintiffs argued that 1. The Pool 2 determination of no case or controversy conflicted with Pool 1's published holding that plaintiffs had standing and the case was not moot, violating the law of the case doctrine and the Fifth Circuit's rule of orderliness. 2. Pool 2's mandate did not affect validity of the fee award. 3. The district court erred by reversing the fee award, absent a direct appeal of that award by the city. And 4. Vacating the fee award was severely prejudicial. Writing for the panel, Judge Douglas first addressed the parties' post-briefing Rule 28J letters regarding Lackey v. Stinney, a December 2024 Supreme Court decision holding that Virginia drivers who obtained only a preliminary injunction were not prevailing parties under Section 1988 subsection B, where Virginia repealed the challenged law absent express judicial intervention, 604 U.S. 192 and 195. The panel distinguished Lackey, noting that unlike the Virginia plaintiffs who received only preliminary relief, these plaintiffs received both a TRO and a declaratory judgment, and the city repealed the charter provision, quote, in direct response to the district court's opinion, rather than independently. The panel held that Lackey's emphasis on judicially sanctioned changes meant plaintiffs here satisfied prevailing party requirements at the time of the fee award. However, Judge Douglas rejected plaintiffs' law of the case argument. The panel acknowledged that the doctrine, quote, generally precludes re-examination of issues of law or fact decided on appeal, either by the district court on remand or by the appellate court itself on a subsequent appeal, citing USP-PS Luded v. Avery Dennison Corp. The panel recognized that plaintiff's argument had, quote, some merit given Poole Lawrence's definitive holdings on standing and mootness. Nevertheless, Judge Douglas held that plaintiffs forfeited any law of the case challenge by failing to seek rehearing of Poole 2 through either panel rehearing or en banc review under Federal Rule of Appellate Procedure 40. The panel stated that plaintiffs, quote, had ample opportunity to file a petition for rehearing, but elected to do nothing and wait for the mandate to be issued. Judge Douglas emphasized that plaintiffs, quote, chose to appeal the effect of the decision rather than the decision itself, and allowed the Poole 2 mandate to undo their prevailing party status without so much as filing a motion before our court. The panel declined to resolve the alleged inconsistency between Poole 1 and Poole 2, reasoning that, quote, this will not overturn the district court's proper application of the Poole 2 mandate, and that plaintiffs' failure to exercise the options before them does not mean that the responsibility to fix their mistake falls into this panel's lap. Finally, the panel rejected plaintiffs' prejudice argument. Quoting Lowry Development, LLC versus Groves and Associates Insurance, Judge Douglas noted that, quote, having a favorable judgment set aside is inherently prejudicial, so some extra measure of unfair prejudice must be present to overcome an otherwise worthy Rule 60B motion. The panel emphasized that, quote, some uncertainty is inherent in an interim award of fees until the case has run the gauntlet of appellate review on the merits, citing Shipes versus Trinity Industries. Judge Douglas found, quote, no justification for plaintiff's claim that the absence of a direct appeal from the fee award authorized counsel to withdraw funds from the client trust account, noting that plaintiffs knew the merits judgment supporting the award, quote, was still on appeal to this court in Poole 2, signaling that any preceding orders by the district court were subject to change when the decision was made to delve into the client trust account. The panel concluded that plaintiff's prejudice claim was, quote, insufficient to overcome the district court's proper exercise of discretion. Analysts comment on the Fifth Circuit's decisions in La Unión del Pueblo Entero and Poole v. City of Houston. These decisions address distinct but related problems in federal court jurisdiction over state election law challenges. The La Unión decision represents the Fifth Circuit's most comprehensive ex parte Young analysis in the voting rights context since Texas Democratic Party v. Abbott in 2020. The provision-by-provision approach yields holdings that create significant doctrinal tension, as Judge Oldham's dissent forcefully demonstrates. The majority's distinction between regulatory authority and enforcement authority attempts to cabin when form design powers constitute enforcement. The panel held that when state officials prescribe forms that local officials must use, and those forms implement substantive legal requirements, the form designing official compels or constrains compliance with the underlying legal requirements. This extends the Texas Democratic Party logic beyond age verification requirements to encompass identification documentation, wet signature mandates, and voter assistance disclosure requirements. The analytical framework is defensible under existing Fifth Circuit precedent. In Texas Democratic Party, the court reasoned that the Secretary's form design authority gave her power to compel local officials because local authorities were required to use Secretary-prescribed forms except in emergencies. The majority correctly identifies this as the critical distinction from Lewis v. Scott and Richardson v. Flores, where the Secretary's role was advisory or ministerial rather than mandatory. Local officials must use the Secretary's forms in Unión, just as they did in Texas Democratic Party. However, Judge Oldham's critique identifies a fundamental problem with the circuit's ex parte Young doctrine that the majority's distinction does not resolve. The issue is not whether the Secretary compels local officials. She plainly does through mandatory form requirements. The issue is whether the Secretary compels these plaintiffs. The organizations suing are voter registration groups and voting rights advocates, not county election administrators. The Secretary's sanctioning authority operates against registrars for substantial noncompliance with overall duties. Her form design authority mandates what questions local officials must ask voters, but neither power gives the Secretary direct enforcement authority over voters themselves. This matters because ex parte Young's entire foundation rests on the fiction that state officers acting unconstitutionally are stripped of state authority and hence lack sovereign immunity. That fiction works only if the officer is threatening to do something to the plaintiff that would violate the plaintiff's federal rights. When General Young threatened to enforce Minnesota's railroad regulations against the plaintiff railroads in ex parte Young itself, the railroads could seek an injunction protecting their constitutional rights by enjoining General Young's enforcement actions against them. The fiction was that General Young, acting unconstitutionally, wasn't really the state entitled to immunity. But what happens when the state official cannot enforce the law against the plaintiff at all? The Secretary of State cannot remove voters from registration rolls. Only county registrars can. The Secretary cannot reject mail-in ballot applications. Only early voting clerks can. The Secretary cannot verify signatures on ballot envelopes. Only signature verification committees can. The Attorney General can sue counties for civil penalties, but not voters for exercising constitutional rights. The majority's holdings allow plaintiffs to obtain injunctions against officials who have zero ability to harm them directly. Judge Oldham calls this the no-nexus rule, requiring connection between defendants and statutes, but not between defendants and plaintiffs. The label is accurate. Under current Fifth Circuit doctrine, identifying any state official with enforcement authority over a challenged statute strips that official of immunity against all plaintiffs, regardless of whether the official can enforce the statute against those particular plaintiffs. This allows organizational plaintiffs to challenge voter registration procedures by suing officials who sanction registrars, not the registrars who actually remove voters from rolls. The consequences extend beyond theoretical concerns about sovereign immunity doctrine. When federal courts issue injunctions against state officials who cannot enforce laws against plaintiffs, those injunctions necessarily operate as prohibitions on the law itself. The court is not protecting the plaintiff from the defendant's threatened enforcement action. It's invalidating the statute. That looks suspiciously like the judicial power to strike down laws that Mitchell and others have argued federal courts lack. And referring potential violations to officials who themselves lack prosecution authority cannot constitute enforcement by the referring official. This reasoning is sound and correctly distinguishes the mandatory enforcement authority in Section 2.06, where the Attorney General can bring civil suits, from discretionary referral authority. However, even the civil enforcement holding in Section 2.06 illustrates the no-nexus problem. The Attorney General can sue counties whose registrars don't substantially comply with voter registration duties, but he cannot sue voters for registering improperly or sue voter assistants for failing to disclose required information. The organizations challenging Section 2.06 represent voters and voter assistance providers, not county registrars. An injunction prohibiting the Attorney General from suing counties for civil penalties does not protect these plaintiffs from having their registrations challenged or their ballot applications rejected. It protects county governments from state enforcement actions. The standing analysis compounds these difficulties. The majority holds that injuries are traceable to the Secretary because she has a role in causing the claimed injuries through sanctioning registrars and designing forms. But that reasoning conflates but-for causation with proximate causation. The Secretary's actions are but-for causes of plaintiff's injuries. If the Secretary didn't sanction registrars or require certain form contents, local officials might not enforce the underlying requirements. But proximate cause requires more direct causal connection than mere but-for causation. The immediate cause of plaintiff's injuries is local officials' enforcement decisions, not the Secretary's regulatory oversight. The standing analysis also highlights tensions between ex parte Young doctrine and modern standing requirements. For Article 3 standing, plaintiffs must show that their injury is fairly traceable to the defendant's conduct and that relief against the defendant would redress the injury. Those requirements normally focus on the connection between the specific defendant's actions and the specific plaintiff's harms. But the majority's ex parte Young analysis focuses on whether the defendant has some connection to enforcing the statute against anyone. Once that minimal showing is made, the court presumes both traceability and redressability for standing purposes. This mismatch between ex parte Young doctrine and standing doctrine is not the majority's fault. It reflects deeper problems with how circuits have applied ex parte Young since the 1970s. But it does suggest that Judge Oldham's structural critique has considerable force. When federal courts apply ex parte Young without requiring nexus between defendants and plaintiffs, the doctrine no longer serves its historical function of protecting plaintiffs from unconstitutional enforcement actions. Instead, it becomes a general-purpose tool for obtaining federal judicial review of state statutes. Now, turning to Poole. The panel's holding that Rule 60b-5 authorizes relief from fee awards based on vacated merits judgments follows directly from Flowers and sister circuit precedents. When Poole 2 held that no case or controversy existed from the beginning, it necessarily vacated all preceding relief predicated on the existence of federal jurisdiction. The TRO and declaratory judgment that formed the basis for the fee award no longer existed as valid exercises of federal judicial power. The panel's treatment of the law of the case issue is more problematic. Poole 1 published a decision holding that plaintiffs had standing and the case was not moot. Poole 2, without mentioning Poole 1 at all, held that no case or controversy existed because parties agreed from the beginning that the charter provisions were unconstitutional. These holdings are flatly inconsistent. Poole 1 expressly found that plaintiffs had reason to believe the city would be seriously intent on enforcing the requirement despite Buckley. Poole 2 found all parties agreed from the beginning the provisions were unconstitutional, citing only the city's brief. The panel's response that plaintiffs forfeited any law of the case challenge by not seeking rehearing of Poole 2 shifts responsibility for reconciling conflicting precedents from courts to litigants. The law of the case doctrine exists precisely to prevent different panels from reaching inconsistent conclusions on the same issues in the same case. When subsequent panels ignore prior published decisions and reach contradictory holdings, that creates a rule of orderliness problem that litigants should not bear responsibility for correcting through rehearing petitions. The Fifth Circuit's internal operating procedures generally require panels to follow prior circuit precedent, absent intervening Supreme Court authority or en banc reconsideration. When a published panel decision establishes the law of the case on a particular issue, subsequent panels reviewing the same case should follow that prior decision. Poole 2's failure to acknowledge Poole 1, let alone explain why Poole 1's holdings should not control, represents a significant departure from normal circuit practice. Moreover, the panel's suggestion that plaintiffs should have filed for rehearing raises threshold questions about whether such petitions would have been successful. A petition for rehearing would have needed to persuade the Poole 2 panel to either acknowledge its conflict with Poole 1 or distinguish Poole 1's holdings. Given Poole 2's complete failure to cite Poole 1, it seems unlikely the panel considered itself bound by Poole 1's precedent. A petition for rehearing en banc would have faced the substantial burden of demonstrating that Poole 2 created an inter-circuit conflict or involved a question of exceptional importance. High bars when the court is simply reconsidering its own prior decision in the same case. The practical effect is that plaintiffs faced an impossible choice after Poole 2. They could seek rehearing with uncertain prospects of success and guaranteed additional delay in a case already pending 6 years. Or they could return to the district court on mandate and appeal any adverse rulings, which is exactly what they did. Penalizing plaintiffs for choosing the latter course, particularly when the alleged forfeiture concerns the court's own failure to maintain consistency between panels, seems inequitable. The prejudice analysis similarly assigns to plaintiffs responsibility for managing risks created by the court's own inconsistency. The panel states that plaintiffs knew the merits judgment was on appeal in Poole 2 when they withdrew fee award funds from the client trust account. But plaintiffs also knew that Poole 1, a published precedent, had definitively held they had standing and the case was not moot. Poole 1 gave no indication that these holdings were tentative or subject to reconsideration. For plaintiffs to anticipate that a subsequent panel would reach opposite conclusions without acknowledging Poole 1 required a level of skepticism about circuit precedent that seems unreasonable to demand from litigants. The Lackey distinction is sound. Unlike the Virginia plaintiffs who obtained only preliminary relief before the state independently repealed its law, these plaintiffs obtained both preliminary and final relief, and the city amended its charter in direct response to court orders. That satisfies Buchanan's requirement that prevailing parties secure judicially sanctioned changes to the legal relationship between the parties. The fact that subsequent appellate review determined the initial judgment was jurisdictionally defective does not retroactively eliminate the causal connection between judicial relief and the city's policy change. However, Pool 2's subsequent determination of no case or controversy from the outset legally unraveled that causal chain for Rule 60b-5 purposes. The tension between Pool 1 and Pool 2 highlights ongoing confusion about Article 3, justiciability in cases where defendants disclaim intent to enforce challenged laws. In Pool 1, the City of Houston's disavowal of the qualified voter requirement during the circulation period did not moot the case. But in Pool 2, parties' agreement that charter provisions were unconstitutional meant no case or controversy existed from the outset. The distinction presumably turns on whether agreement about unconstitutionality eliminates adversity even when parties dispute relief. These cases arrive at the end of a year that saw significant Fifth Circuit activity on ex parte Young issues. The court's October 2024 decision in Mi Familia Vota v. OG established that states can take interlocutory appeals of sovereign immunity denials even when immunity would not dispose of all claims. The December 2023 Ostrowich decision held that the Attorney General lacked sufficient connection to Election Code criminal penalties to overcome sovereign immunity. And the June 2024 Book People Inc. v. Wong decision addressed when booksellers can sue the Attorney General over content restriction statutes. In conclusion, collectively, these decisions reflect ongoing circuit confusion about fundamental questions. What connection must exist between state officials and state laws to support ex parte Young suits? What connection must exist between state officials and specific plaintiffs? When does regulatory authority become enforcement authority? How should courts handle cases where multiple state and local officials share implementation responsibilities? Judge Oldham's La Union dissent argues for wholesale reconsideration of circuit precedent. Whether the en banc court takes up that invitation remains to be seen. But the analytical tensions he identifies, particularly the no-nexus rule that requires no connection between defendants and plaintiffs, warrant serious attention. Federal courts' power to enjoin state officials exists to protect plaintiffs from unconstitutional government action, not to provide generalized mechanisms for obtaining federal judicial invalidation of state statutes. When ex parte Young doctrine loses sight of that distinction, it risks exceeding both Article 3 limits and the historical scope of federal equity power. This concludes the special edition WCAG Wire for Friday, January 2, 2026.